One of the most popular questions that I get from inventors who want to license new products is all about patents. Which one to get and when to get them. Well, in this video, I'll show you not just the legal strategies behind each one, but when to get which one and why so that you can make your own intelligent business decision about them. Hi, Lisa Lloyd here with more tips, tricks, and strategies to help optimize and accelerate your invention licensing business success. If you're new here or a returning visitor, welcome. And if you like this video, please tell YouTube by hitting that like button and hit subscribe. It's a free way to support me doing this, and if you want more like it, then smash the notification bell to be the first to know whenever I post a new video. Patents are not required to make and sell a product, but you cannot make and sell a product that someone else has a patent on. Make sense? That's simple enough. So you can sell anything as long as no one else has legal protection on that. If you want to stop others from selling something that you cooked up, then you can file a patent application with the United States Patent and Trademark Office to protect it. Once you submit a patent application, you're allowed to tell the world that you have a patent pending on it. That means that the USPTO is currently reviewing it and considering whether or not to allow it. You will remain patent pending until either the patent office rejects it and/or you abandon it, or you're approved, at which time you have an issued patent and you can say you're patented. So you're pending first and then have an issued patent. Get it? All right, so building on that, while you're pending, like I said, you can tell everyone that the product is patent pending, and that puts them on notice, but legally you still don't own the rights. That just gets locked in later when the patent issues. If you want to license your invention, most companies will consider it while you're still pending. But obviously they will want to review that application to make sure that it's going to be strong and when and if it issues. And if it does, they will need to review that to feel confident that they can enforce or defend it if one of their competitors knocks it off. So let's review your options for patent protection and when it makes sense for each of them so that you can make your own smart business decision with your legal dollars. Now, first of all, there are plant patents, and I'm not going to dig too deep into that because my guess is there's not a lot of people in the sound of my voice that have invented a new peach, for example. Then we have design patents. These are essentially covering what the product looks like. This is basically one claim explaining what that product is and a number of drawings showing all of the parts from all the different and important angles. They're good for 14 years from the date that the patent issues. So design patents make the most sense if why people will buy it is based on how it looks. So if people will buy your product because of what it looks like to have whatever transformation or promise that you're going to deliver with it, then a design patent is probably the right choice for you. However, if the same function can be achieved by making a design different enough, then this will not have the broad enough protection, and you may need a utility patent instead. Now, a utility patent covers what it does. It has many claims that explain how the parts all come together to perform a specific function. So it makes sense that the more claims that you have, then the broader your protection will be. They're good for 20 years from when you first apply for the patent. And the application process can take years. So theoretically, you could be pending for a few years, say 3 years, and then when it issues, only have 17 years left on that patent. With a well-drafted patent, you make it harder for someone to make it any other way that comes close to the variations that you think up around your invention. So as you can see, it's important to do this right and well because not only will a prospective licensee review it for its strength, but you will depend on this if your product does well and find yourself needing to defend or enforce it, the rights anyway, in court someday. And hiring a professional will always be better than, I guess, just doing it yourself. That said, this is a business, and as inventors, if we're going to treat it like a business, then we need to take into consideration it's extremely risky. And mitigating that risk will minimize our potential losses. One way to minimize your financial risk is with a provisional patent application, or PPA. Now, this is an optional first step to a utility patent application. It allows you to file an extremely scaled back version of a utility patent application with just the description of the invention and the drawings or even photos to illustrate it. So there's a lot less information required and much looser rules for following through with. Once you've officially applied using a PPA, you can begin using the term patent pending just like with the design and the utility application. But unlike them, it's not examined when the USPTO receives it. Instead, it's stamped with a date that it was received by them and put on a file, and that would be considered the date of your application. Then you're given up to 12 months to convert that PPA into a utility, also called a non-provisional application. If you choose to move forward with the invention and invest in a utility application at any time during that 12-month period, then the USPTO examiner will review your PPA to confirm that it is indeed the same invention and keep that earlier filing date of the PPA. So for example, if you file a PPA in January 1st of this year, and then you convert it to a non-provisional or utility application in September of the same year, the filing date for this new utility application will assume the date of the original PPA. This only matters because when you want to have the earliest filing date in the event that someone else tries to claim they invented it first, he who got that application first wins. So the benefits of filing a PPA are it's much less expensive with the filing fees for the United States Patent and Trademark Office and with most attorneys because it just takes less work to file a PPA. It buys you more time to work out the fine details and safely talk about the product idea while you're patent pending. So you can chat with people who you need help from or companies that you'd like to pitch it to before you go forward with investing in a very expensive utility patent application. Can you see how that mitigates your risk? If the company's interested, you get the deal, you can use that money then to pay for your utility application to convert the PPA. And if they're not interested, then you can choose to walk away and it will have cost you less to make that choice. This is brilliant for business as a strategy, but it's not a one-size-fits-all. There is a time and a reason for each of these, and knowing the difference will make you a better inventor. Or as I like to say, inventaneur. Yes, I just made that up. An inventaneur is an inventor that treats inventing like a business, not like the lottery or on a wing and a prayer. So for example, if you've done your research and you've looked at companies who might be a good fit for licensing your product and determined that that category requires an issued patent, filing a PPA may or may not make sense anymore because obviously you're not going to be issued during a PPA period. You still have to pay then to convert it to utility. So why not just go straight to utility and save the dollars and time that you would have on a PPA? Because you need to get the patent issued before you can even pitch it to the company. On the other hand, if you're still R&Ding it and working through it, a PPA might make sense because you're fleshing out the full theory, concept, features, functionalities, benefits of the product during that period. On the other hand, if you have something that is aesthetic in nature, like a hair accessory with a really beautiful bow that is just very unique, even though it can be made small or large, it doesn't matter. A design patent may be effective enough to get you across that hurdle. There are times where you can use both a utility application and a design patent to even further insulate yourself against potential infringers. And then, of course, the best option of all with PPAs in particular is that if you're really not sure, which most independent inventors don't have the background, experience, etc., wisdom to draw from a career in hair accessories, again, as an example, to make an intelligent decision or work off of your gut to know if you should move forward with it. So a PPA makes more sense than spending a lot of money on it unless you have gotten that confirmation first. It's a good way to go get that confirmation instead. So it's a good business strategy for mitigating your risk and then therefore improving the ROI, which is return on investment for your invention. As an inventaneur, you will know which one will get the job done. And knowing the answer is the most important question that you have to answer for yourself to make good business decisions here. Of course, there is so much more to it than I can tell you simply here, but I hope that you see these basic facts can help you to shape your decisions and make you a smarter inventor. If you want to level up your invention licensing strategies, book a free call to learn how we can help. And if you like what you learned here today, please consider sharing this video with others, and don't forget to like and subscribe. Dare to dream and imagine what's possible when powered by innovation. Patents are not required to make and sell a product, but you cannot make and sell a product that someone else has a patent on.